He was still in the house. He came out about 5 minutes later, soaking wet, and looked at me and said, sorry, I just shit in your pool. And yes, he did. And we have video of everything.
Good morning, Your Honor. Your Honor, I believe we have victims here on the Daniel Rooney case, so I would request to do that one first, if possible, if they're present. I would ask the clerk if they're present yet.
They are present, so let me just grab Mr. Rooney.
Rooney, you can come up and stand by me.
All right. So again, good morning, everyone. Just for the record, I've read through each one of these files, so I'm familiar with the facts of the case, court assessment, pretrial services notices, and the other information, as well as the risk assessment, as well as the other information in the file. All right. So is the state ready to proceed with Mr. Rooney?
Yes, Your Honor, the state's ready to proceed. Your Honor, I do believe that the victims wish to give a statement to the court, so I'd ask that they be permitted to do so at the appropriate time. The state's requesting bail in the amount of $50,000, DAS with testing for drugs and alcohol if he posts, and of course, no contact with the victims or their residents, and no firearms or weapons. So Mr. Rooney scores a 3 on the risk assessment. He has no prior documented criminal history. However, this is one of those cases where on balance, the facts of the case weigh in favor of setting monetary bail. Your Honor noted you read through the PC sheet, so Your Honor is well aware of the alarming facts of this case, where the victims were at their house and Mr. Rooney entered the house and he actually battered both of them. It's my understanding they're both over the age of 60. So this is on an elderly person, on 2 elderly people. And so as well, Your Honor, the likelihood of conviction appears to be very, very high in this case. We know that the victims have a home surveillance system set up in their house. So everything was captured on video. And Mr. Rooney himself made a number of admissions. And so for all these reasons, Your Honor, the state is requesting bail in the amount of $50,000, DAS with testing for drugs and alcohol if Mr. Rooney is able to post, no contact with the victims or their residents, and no firearms or weapons. And with that, I'll submit, Your Honor.
Okay. So Ms. Meyer?
Thank you so much, Your Honor. Your Honor, with respect to bail, we are going to be asking for OR, and I believe that that is justified under Valdez Jimenez. In looking at the case, while I respect the significant nature of the details in the probable cause sheet, what Valdez Jimenez does is instruct this court that it must find clearly and convincingly that no less restrictive means other than monetary bail are appropriate, and presume that monetary bail is not the starting point. In this case, we have a gentleman with no prior criminal history who we were able to speak with his mother. His mother does confirm that she has an address on Vista, Favoloso, excuse me, and that there was a prior address on Mountain Vista Way that he was employed. In this case, it appears that there was a crisis-like event that was occurring when this happened, that family was attempting to address that. Your Honor, with an OR, we would either ask for an ankle monitor to be installed before he leaves, understanding the impact of this case. That would be a less restrictive and appropriate means to secure location and tracking without having the necessary monetary bail, which is disfavored by Valdez Jimenez. In this case, again, that NPRA score suggests that there is a significantly low risk of recidivism. And while I think it's appropriate for the state to look to the likelihood of conviction, Valdez Jimenez doesn't get there until other clear and convincing elements have been established. Another non-monetary oversight the court could impose is a mental health or substance use evaluation to be scheduled within 48 hours and to be conducted within a week, or proof that it has been scheduled, I think would be appropriate in this case. So knowing what the Supreme Court has instructed us, absent that clear and convincing showing, and with the presence of the ankle monitoring system, pretrial services, and other non-monetary means, I believe that this court can tailor a less restrictive means and is required to under that case law. We do have mom saying that she would be helping him make appointments, that there is support for travel and connections to the local community. So even were the clear and convincing showing made, I think that there are other means that this court could look to. With that, absent questions from the court, I would submit.
All right, when you talked to the mother, did you verify her address? Is the address 1941 Mountain Vista Way?
No, that was, sorry, that was the prior address so that he would not be living alone and would be in a supported setting. It is, and I don't, unless this court requires it, putting addresses on record, I would just ask to be able to say it's Vista, Vista, Favoloso, Favolloso, Reno. And the street address, which begins with a 3 and ends with an 8, could be provided to court services at the time of release if this court will allow him to be released. That 1941 Mountain Vista was his prior residence, but since he had been living there by himself, we were able to speak with Lana, yes, and she confirmed that he could stay with her to enable some oversight. Does that answer the court's question? I'm sorry.
So you said Vista, and then what was the rest of the name of the street?
Favoloso, Favoloo.
All right. All right, so I want to ask Ms. Darby, pursuant to the administrative order, there would be no 10% cash option on this bail, correct?
That's correct, Your Honor. This is a Category B felony with a human victim.
All right, so let me hear from William, and it looks like Joe and William Vanderbeek. Did you want to, or Vanderbeek, did you want to make a statement? Looks like you're muted.
There you go. Can you hear me?
Yes.
Okay, sorry. I wasn't prepared. We just got a phone call before 8 o'clock this morning that this was happening and wanted to know if we wanted to be part of it. But I was home alone and I heard a noise in my house and I went to check it out and he was there. And I said, "Who are you?" And he said, "You know who I am." And I'm telling you how scared I was. He told me I wanted him there.
Ma'am, I'm so sorry if I may interrupt. Your Honor, just with respect to the Vanderbeeks in this case, it appears that we are being recorded pursuant to policy. Recording of this needs to be given permission, and I want to confirm that this is not being recorded on the phone that I see present on the video surveillance or video feed, because that is not permissible.
You're not supposed to.
I can turn it off. I didn't know.
That's fine, sir. I just wanted to make sure. Thank you.
Okay.
All right, is that satisfactory?
Yes, thank you, Your Honor. I just wanted to make sure we were honoring the restrictions on video recording.
All right.
Thank you.
Should I continue?
Yes.
Wait, he told me that I wanted him there. And at that point, I really feared him. And he, let me tell that you weren't here. And he approached me and he put his hands on me and, held me like this. And I managed to wiggle out of that. And he told me again how I wanted him there. And then he told me that God told him to come there. So at that point, I feared rape. At that point, I feared death. And I stayed calm and I suggested we go outside. And he said no. And I thought, I'm not going to run. And I walked to the back door and I realized that he had locked the back door after he entered. And that was a oh shit moment for me. I knew I was in trouble. But I did get out. And that's when I saw his friend and asked who the hell he was and told him to call 911, and he didn't. But my husband drove up right at that moment and I fell apart. I thought my life was in danger and I definitely feared for what he was going to do to me. And he was still in the house. He came out about 5 minutes later, soaking wet, and looked at me and said, "Sorry, I just shit in your pool." And yes, he did. And we have video of everything. And he then, when he came out of the house, he walked towards my husband with his arms out, and my husband held his hands back. And then he went after me, and he just pushed me like a football player, pushed me about 8 feet, and I was screaming. And my husband went after him, and he went down. My husband went down. I don't know if he tripped or he lunged at this guy or if he was pushed down. You really can't tell. But he was on the ground. And it was, I took a picture of the car, and my husband told the driver, do not leave, because the police, everybody was called. And we had 7 police cars, an ambulance, yeah, everything was there. And they took over from there. And I'm a rep. And I don't know why he's smiling.
Yeah, I don't know why either.
By
So,
the way, we think he's been at the house before. He knew exactly, you don't see our back door from the front. And he knew exactly where he was going. We have videos of the front of him pointing to the driver where to let him off at the back door. He didn't attempt to go to the front door because we have cameras out there too. There are no cameras at the front door.
right, and that's consistent with the probable cause sheet that I read, that apparently he'd gone by your house multiple times and always wanted to go in there, and eventually he did.
Well, about 9 months ago, somebody did come to our backyard at 3 in the morning and knock on a plate glass window. And Thursday, my husband said, I'll bet it was this guy. He knew the house.
Yeah, well,
So we're very afraid.
He admitted that much in the probable cause sheet, as the Ms. Darby mentioned. There were several admissions, obviously video, obviously everything you said is in the probable cause sheet. He was on his way to a rehab center and obviously admitted was high on ketamine. So that's the concerning part of this, is that without proper medication, he could do something like this again. So what I'm gonna do is I'm gonna set his bail at $30,000, no 10% cash option, no contact with Joe and William Vanderbeek, no contact with 8771 Lakeside, which is in Reno. He'll be subject to residential confinement. He'll have to be fitted with a GPS device. Fitted with a GPS device before release. He'll be subject to drug and alcohol testing on a random basis. Shall not possess firearms or weapons. DAS or court services will have to verify that he can live with his mother and that she will be able to take him to his hearings and make sure he gets a mental health evaluation within 48 hours. And he'll have supervised check-ins. Again, no possession of firearms or weapons, no 10% cash option, given the facts of this case.
Your Honor,
Right?
Your Honor, please,
Yes.
just to clarify, this court is finding that the PC sheet alone is the clear and convincing evidence that shows nothing but monetary bail is appropriate. Is that correct?
That's correct,
Thank you.
based on video and based on his admissions.
The defendant indicated he was gonna.
Right, so that's the other thing I needed to verify. I allowed you to represent him for purposes of this bail hearing. But what he did say in his documents that he was gonna retain private counsel. I don't think that's gonna be the case. So
No,
the
Your Honor,
intent
we have
is-
spoken. Again, as an
Right.
officer of the court, I know that you think our statements need to be validated, but as an officer of the court, we've spoken with his mother. She states that he did have some employment, but is not now employed. There are active concerns regarding an SB 89 potentially in the future. In this case, we would ask to be able to represent him based on the totality of the circumstances and conversations with Lana that suggest that he falls within the indigent range.
I would agree with that, so we're gonna appoint him a public defender. All
Thank
right?
you.
So let me sign that. Thank you for your testimony. All right. You're telling me.
And
Okay,
Your Honor, again, it is not the Vanderbeeks, it does not weigh on their shoulders at all, but just, there's no posting of that video anywhere because it is a hearing that it was not noticed as a recorded hearing, please.
all right, so you made that clear on the record, so,
Thank you.
and they said they weren't recording.
You could delete that.
All right, so if you did
you very
record it, please delete it. All right,
It'll be done.